Good morning, everybody. Welcome to today's webinar. Our topic today is Ask a Pro, Navigating Chapter 11 and Chapter 12 Bankruptcies. And as many of you know, this is part 2 of our 2-part bankruptcy series. My name is Scott Fink. I'm a shareholder with the firm, Weltman, Weinberg & Reese, and I will be the moderator for today's session. I manage the bankruptcy practice group here at the firm, and I also focus on consumer commercial bankruptcies, and I'm also involved in the firm's real estate default group. Before we get started, I want to take a moment and go over a few housekeeping items. We want to make sure that today's presentation is valuable for you, so we ask that you submit all your questions by clicking on the question button in the control panel and typing your questions. Those questions will only be visible to me, and they'll be addressed throughout the presentation. So let's now learn a bit more about our panelist, Jeff Peters. So Jeff is when we say Ask a Pro, he's our pro today. Jeff is a shareholder with the firm out of our Columbus office. His primary focus area is in bankruptcy, and he's also involved in our real estate default group. Jeff is a member of the New York, Florida, and Ohio State Bar Associations and is licensed in Florida, New York, and Ohio. He's also admitted to practice before the United States District Court and the U.S. Supreme Court. Jeff has 25 years of experience in the creditors' rights industry. So without further ado, welcome, Jeff. Thank you for taking part in this, and let's go ahead and get on to the first question. So our first question is what I'm going to call a real table setter that should cover a lot of different areas as a general proposition here, and we can use that to build off of things as we move forward. First question, as you can see, is what's the main difference, Jeff, between a Chapter 11, Chapter 12 bankruptcy, as opposed to the more commonly used Chapter 7 and Chapter 13 bankruptcy?
Thank you, Scott, for the introduction, and welcome everybody to the Ask a Pro series. I think the easiest way I can explain this is by going over just a few of the details of 7, 11, 12s, and 13s. The details being who can file, the purpose of the filing, and there's also some debt limitations that go along with each of those chapters. So, for example, Chapter 7, who can file a Chapter 7? Generally, and most of this conversation today is going to be talking about individual bankruptcies as well as corporate bankruptcies. So, in a Chapter 7, both an individual and a corporation can file a Chapter 7 bankruptcy. What most people don't know is that only an individual can get a discharge in a Chapter 7. A corporation cannot get a discharge in a Chapter 7. A Chapter 7's purpose is basically to liquidate the debts. If the debtor really doesn't have any equity in any of their assets, and they just want to get rid of debt, they'll file the Chapter 7 and get a discharge. Chapter 13, who can file a Chapter 13? Only an individual can file a Chapter 13. A corporation, a limited liability corporation, any non-individual cannot file a Chapter 13. The purpose of the 13, as well as the 12 and 11, is a reorganization. So the debtors in each of these chapters are trying to reorganize so that they can pay these debts. There are some debt limits associated with the 13. The unsecured debt limit is just under $420,000, and the secured debt limit is just under $1.3 million. So if a debtor has too much debt over those limits, they can't file a 13. So what do they do if they can't file a 13? Well, they'll use one of the other reorganization provisions, which is a Chapter 11. So a Chapter 11 is both an individual and a corporation can file a Chapter 11. And again, the purpose is to reorganize their debts. And there are no debt limits with the Chapter 11. Last but not least, the Chapter 12. Who can file that? That is limited to family farmers and family fishermen. And again, the purpose is to reorganize their debts so that they can pay and keep their assets. And there are some debt limits associated with the Chapter 12. prior to this past year, the debt limits were about $4 million. There was a new law entered last year increasing the debt limits to $10 million. For the family farmer, for the family fisherman, the debt limits are just under $2 million. So the main difference really between these, Chapter 7 is a liquidation, Chapter 12, 11, 12, and 13 are reorganization provisions, which are limited by who can file and limited by the amount of debt those debtors have.
Thank you, Jeff. And just a couple of other follow-ups for everybody before we move on to the next question. In terms of the plan itself, it's a reorganization plan is what they're driving for in Chapter 11 and 12 and 13. Can you just kind of give everybody the broad strokes of the differences in that process of how a debtor or debtor in possession moves ahead with filing a plan and getting it approved in 11, 12 versus 13?
Sure. The Chapter 11 process, for example, it's supposed to be a pretty speedy process. So the debt limits are there because they're not going to be real complex bankruptcies. So in a Chapter 13 case, a plan is going to be filed pretty much at the onset of the case. Most Chapter 13 filings have a plan filed on the day of when the petition is filed. And if it's not filed, it's typically by jurisdiction, it's due within 14 days of the bankruptcy filing. The Chapter 11 and 12 are a little bit more complex. One of the reasons is there's more debt. The Chapter 11 and 12 process may have some negotiations that need to be done in negotiating a plan with the secured debt holders and frankly all the creditors in the case. So that's why there is some in the statute, there's some built-in time for a Chapter 11 and Chapter 12 plan to be filed. So in Chapter 11, those debt, I think that's one of the questions in the future, but it's within 120 days of the bankruptcy, and with a Chapter 12, it's 90 days from the date of the filing.
Thank you. All right. Let's move on to our. And that question is, what debts are dischargeable in bankruptcy? Which is a common question we get from many of our clients.
Well, if we have some repeat viewers from our Ask a Pro series a couple weeks ago, I'll give the same answer that Monette gave because it's the same answer. But generally, all debts that are included in a bankruptcy petition are going to be non-dischargeable. There are exceptions to that, obviously, and most of those are in Section 523 of the Bankruptcy Code. And Section 523 applies to, it's in Chapter 5 with the first number there, 523 stands for Chapter 5. And Chapter 5 applies to most of the bankruptcy other chapters, the 7s, the 11s, 12s, and 13s. So some of those are certain taxes and fines, debts arising from fraudulent conduct, debts emitted from the bankruptcy petition and schedules, alimony, child support, debts caused by debtor's willful and malicious injury to another person, student loans. Those are the main ones under 523. I will note that most of these are presumed to be non-dischargeable. However, a creditor, it is incumbent on a creditor to file what's called an adversary proceeding in the bankruptcy case for certain of these to get the judge to declare those debts as non-dischargeable. The main ones are the fraudulent conduct and the debtor's willful and malicious injury to another person. Those have to be presented to the court, and the court has to enter a finding that those are in fact non-dischargeable.
Is there anything special about Chapter 11 and 12 when it comes to discharging these debts?
Well, the chapter 11 and 12, these are going to apply. There is some case, if you look at the statute under section 523, it appears to apply just to individuals. But there are provisions within the code that actually, and some case law out there that actually apply these, this section 523 to corporate debtors. So there are instances where these can be found to be non-dischargeable in the corporate context.
All right, let's move on to question number 3. This one is, or does a co-debtor, well, question, does a co-debtor stay exist in all chapters of the bankruptcy code? But I want to also ask a side question of that. What is the co-debtor stay? There's probably people saying, well, I don't know what a co-debtor stay even is. We'll start with that and then talk about where it's applied.
Okay, yeah, a co-debtor is just that. It's somebody that's obligated on a debt with the debtor. So husband and wife both sign an obligation for a car note, and only the husband files bankruptcy. The wife is a co-debtor on that. And in my example, she didn't file bankruptcy. So the question is, can you proceed on that debt against the wife? Does that automatic stay exist for that wife? Or can a creditor just proceed against the wife because she didn't file bankruptcy? So that's the question then is, does the co-debtor stay exist in all chapters of the bankruptcy code? And it does not. The co-debtor stay only applies in cases under chapter 12 and 13. But it's important to note that co-debtor stay only applies to consumer debts. So if a co-debtor signed on an obligation for a commercial debt, the co-debtor stay does not exist in any of the chapters under the bankruptcy code.
And I do want to add for everyone, you know, when we're saying the co-debtor stay does exist and does apply in chapter 12 and chapter 13, that doesn't mean you don't have options to go after that non-filer. It just means you have to take one extra step. And what that would mean is filing a motion within the chapter 12 or chapter 13 bankruptcy, asking the court to lift or seek relief from the co-debtor stay. It's not a very difficult hurdle to clear in most situations. You basically have to show the court, I've got someone else who's liable on the debt with the bankrupt debtor. The plan itself does not provide for 100% payment to us as a creditor, and continued imposition of that co-debtor stay is going to unduly harm or burden or prejudice me as the creditor. Those are really the 3 hurdles that you've got to clear. And as long as you can show that, you get the co-debtor stay lifted in most situations.
Actually, I've seen over the years, I remember years ago, and I haven't seen it in a while, but some of our clients, they may have a lot of co-debtors on a loan. So I remember a situation where I think it was a firefighter and maybe his colleagues at the fire station. They all signed on each other's notes. So when one of these people filed bankruptcy, there was 15 or 16 co-signers on these notes. So when that chapter 13 was filed, we had the option, or the creditor had the option of filing co-debtor relief from stay against those 15 or so co-signers. But the co-debtor stay is there just to give an opportunity for the debtor to kind of protect those co-signers if they so choose. But as we've said that if the co-debtor isn't protected, we can proceed with a motion before the court.
And just for everybody listening, when Jeff says how, you know, protecting the co-debtor, the way that would have to happen is within a chapter 12 or chapter 13, the bankrupt debtor would have to put a provision in their plan that makes sure that that particular debt is being paid in full. That's the only way you're truly going to protect the co-debtor, is by providing for that debt 100%, even if all your other similarly situated debts are getting crammed down or are being paid less. So if you've got a credit card, for instance, and you want to protect the co-signer on it, you'd have to propose in the plan, I'm going to pay this credit card 100 cents on the dollar, which can present its own set of problems. Because the courts, the trustee, and other creditors are going to probably have an issue with that. Why is this creditor being preferred over others? The reason's obvious, because you want to protect the co-debtor, but everyone else is going to raise their hand and say, well, what about me? So it becomes an issue. But I've seen debtors attempt it. Some successfully, some not. All right, so next question. Let's move on to question number 4. So we touched on this before, but who is eligible to file for relief under Chapter 12?
So Chapter 12 is reserved for the family farmer or the family fisherman. And as I said in question number 1, there are some debt limits there. The Family Farmer Act, I believe it was, increased the debt limits to $10 million. And the debt limits for the family fishermen are about 1.9 million, just under 2 million.
And in terms of, let's just say there's a family farmer or fisherman who runs into financial difficulty and has really no stable source of income at this moment, can they file?
Yeah, well, actually, I did want to go into some of the benefits of why would somebody file a Chapter 12 versus a Chapter 13. And one of those benefits is that the Chapter 12 does allow for the seasonal payments. So I think that was your question, Scott, if they don't have an immediate income. So the Chapter 12 versus the Chapter 13, there is 90 days to file a plan in a Chapter 12. The filing fees are less. I know that's a minor point. There's some noticeable tax liabilities differences in Chapter 11 versus the Chapter 12. If the family farmer were to sell some assets during a Chapter 12 plan, any tax arising from the sale is deemed as unsecured and can be discharged in the case. Versus Chapter 11, if there was an asset sold within a Chapter 11 plan confirmation process or even prior to that, the capital gains have to be paid in full at confirmation. So there's some clear advantages to file a Chapter 12 over a Chapter 11. Also, in a Chapter 12, you can modify any secured loan in Chapter 12 versus 13. There's some restrictions on what can be modified and what can't. And the clearest example is in a Chapter 13, if the debtor owns a home, they generally can't modify that mortgage on their home. And in a Chapter 13, in a Chapter 12, there can be a modification to the regular monthly payment in the simplest terms. So, but yeah, that's really, so there are some clear advantages to file a Chapter 12 for those family farmers or fishermen if they can.
Thank you, Jeff. And I'm getting a few questions that are coming in, and I should have added, we'll kind of plug these in along the way, and thank you for the questions as you're sending them. One of the questions that was posed is sort of what's the time length of a Chapter 11 and 12 case? What's the life cycle like? I know it varies, but
I'm sorry, you cut out there. Well, the timeline of what chapter?
What is the time length of a Chapter 11 and a Chapter 12 case?
Oh, yeah. That's kind of a loaded question because a Chapter 11 can take various forms. So a Chapter 11, typically we think of as maybe a big corporate filing that's out there. Those can take, the bankruptcy code provides certain deadlines for those big corporate cases. A plan has to get filed within 120 days of the bankruptcy case, but it can be extended. The statute provides up to 18 months. There's a new Chapter 11 subchapter. It's called Subchapter 5. It's not a Chapter 5 bankruptcy filing, but it's under a Subchapter 5 under Chapter 11, and that's called the Small Business Reorganization Act. Small Business Reorganization. This is a law that was just passed and effective in February of this year. That's for the smaller business cases with debt limits currently under $7.5 million. When that act was passed, it was a $2.7 million debt limit, but with the pandemic, that was increased to $7.5 million, which expires at the end of March, and it goes back to the $2.7 million. But in those small business cases, a plan is due within 90 days of the bankruptcy filing. And the small business case was enacted to allow those smaller businesses to get through Chapter 11 very quickly. There's a lot of details, a lot of filings that aren't necessary in a corporate filing versus a small business filing. So you're going to have much quicker confirmations in the small business case. And then in an individual Chapter 11 case, the plan is due within 120 days, but typically in the individual cases, those are going to last between 3 and 5 years. So sorry, but there's 3 different answers for those Chapter 11s. And in terms of the Chapter 12, those plans are also due within 90 days. And those plans can be extended. And I'll quote from the statute here, for circumstances for which the debtor should not justly be held accountable. So the courts are going to grant, it is a debtor's court, so most of the time the debtors are going to grant extensions for plans to get filed in the Chapter 12 cases.
And in terms of how long the repayment, the type of repayment terms you see in a plan. I mean, I know Chapter 11, you can have repayments that stretch out quite a while and take various forms. Can you expound on that a little bit, and also what you typically see in a Chapter 12 repayment plan? Sure.
In the Chapter 11s and the larger corporate Chapter 11 cases, like you said, the repayments can vary greatly. The key with a corporate Chapter 11 is once the plan is confirmed, the debtor receives their discharge. So that plan becomes the new contract. And if they ever defaulted on that Chapter 11 plan, when you go to court to sue on it, you're waiving that Chapter 11 plan to the court that you're in and saying, hey, look, the debtor did not abide by this Chapter 11 plan, because that's your new contract. So with the vehicles, with equipment, I generally see about 5 years on residential mortgages. We'll see a reamortization over 30 years. With commercial property, I'll see a lot of times maybe a 15-year term with maybe an acceleration clause after 7 years. So it really runs the gamut of the repayments. And a big part of this too is the reason so much time is given in order to file a plan is these debtors' attorneys are reaching out to the creditors. They're trying to get an agreement so that they can include it in their plan, because ultimately the creditors will need to vote on the plan to get approval from the court. And it's much easier to confirm a plan obviously with a consensual plan with the creditors than not. In terms of the repayment plans in individual Chapter 11, that's going to really mirror the 13 repayment plans, because the individual Chapter 11 plans were statutes were really based on the Chapter 13 statutes. So the debtors are contributing all of their disposable monthly income into the Chapter 11 plan like a 13. And they're typically paying their vehicles over the 3 to 5 year period. They're catching up their mortgages. But the individual Chapter 11 was really put there. It's based on a 13, but without the debt limits. It's for those higher debt individuals and higher income individuals. In terms of the Chapter 12s, Chapter 12s are pretty similar, but we see a lot of one-time annual payments to the Chapter 12 creditors because the family farmers have different periods of the year in which they have income. So a lot of times I'll see these plans that after they get their harvest, they're making one annual payment for the year at the end of October or the end of September, whatever suits that particular debtor.
The other thing I want to add is in these larger corporate Chapter 11s, one of the other things that will cause these quote unquote repayment plans to take so long is where's the money coming from? Well, there's a lot of times there's a series of trusts created that are designed with as a trustee appointed, and they are gathering up funds from different sources in order to repay creditors. And that could be preference claims against creditors who receive monies within the 90 days before the bankruptcy. It could be clawbacks against principals or those closely associated with the company or who committed malfeasance. There could be other litigation that's out there that they need to prosecute, to turn into a judgment and collect on it. All that money will ultimately fund portions of the plan, oftentimes to pay unsecured creditors, and that can take a while. That's all part of the the process to generate funds to repay creditors. So another question, and I apologize. I was going to ask this question or chime in right at the beginning when Jeff mentioned about the fact that a Chapter 7 corporate debtor does not receive a discharge. And there was a question posed regarding that Chapter 7. If business does not receive a discharge, what does this mean regarding the debt that was included in the bankruptcy? Is the business still responsible for anything? So I'll take a stab at it, and Jeff can certainly chime in as well. What really happens in that situation is the business is being wound down. The affairs of the business are being wound down by a trustee in Chapter 7. He or she is liquidating that business. So at the end, there really isn't a business to run anymore. All the assets that had any value are gone. The business is not operating anymore. And while it doesn't receive a discharge, in essence, it is a business that is no longer operating. So in theory, there's nothing to really go after, and there's not a reason to. However, it is still a legal entity that exists, and you could pursue it if you wanted to, because that debt does still exist. But by all, for all intents and purposes, it's an entity that affairs have been wound down. Does that sum it up, or Jeff, do you want to take it further?
No, I think that sums it up. Sometimes a trustee will not see that there's much value there, but if another creditor believes there is some value in liquidating something that, like you said, the debt is still there, and once the case is closed and the trustee took a stab at what they believed was available for possible distribution to the estate, once that case is closed, the creditor can proceed. Yeah.
Okay, perfect. All right, well, let's move on to question number 5. All right, so this one is Chapter 11 debtor in possession.
Yeah, so the Chapter 11 debtor in possession is really the debtor. So when the debtor files immediately prior to filing a Chapter 11, that is the debtor, your debtor, the creditor's debtor. Once they file a Chapter 11, they immediately become a debtor in possession. What everybody needs to realize is when a debtor files a Chapter 11, there's no trustee that's immediately appointed, like in a Chapter 7 or in a 13. You may see, if you ever look on the docket, that the United States trustee may be on the case, but they're not the same thing as an operating trustee, like a trustee in a Chapter 7 or 13. So when the debtor in possession is in a Chapter 11, they really basically are operating the business. And I think we had a question that was posed prior to today is why isn't there a Chapter 7 trust? Why isn't there a trustee appointed in a Chapter 11 immediately? It's because the debtor basically gets a second bite at the apple. They get an opportunity to try to reorganize their business. If you think about it in practical terms, if a huge business files bankruptcy and a trustee is immediately appointed, they really don't know anything about that business going in, and it would probably be deemed it would go down quickly in flames, because that trustee would probably need some time to get up and running. So the debtor in possession, once they file, they can immediately get to work in trying to reorganize, shed some assets that they don't want, talk to creditors, trying to put a plan together. A trustee can be appointed at a later time if the creditor believes there's some fraud going on, or if basically if it's in the estate's best interest to appoint somebody else.
So basically, for everyone, we're all familiar with the concept of the term debtor. Someone files, an individual files a Chapter 7 or 13. The distinguishing characteristic here really is that quote unquote debtor in Chapter 11, they, at least initially, unless and until a trustee gets appointed, they get to control and operate their business. They maintain control of the business or their own financial affairs if it's an individual. And if there's anything I want to add on that one as well. So a couple other things I wanted to just out there. The debtor in possession in Chapter 11 also has the ability and the right to employ professionals in the case to help them to get their affairs in order and reorganize. That could be accountants, could be special counsel, other lawyers, appraisers, auctioneers, any of those kinds of things. They have that ability to hire those professionals. And I don't even remember if this is another question coming up, but I'm going to cheat and sneak ahead if it is. Who then really even though there's not a trustee, a case trustee, Jeff, who kind of oversees and keeps a watch on the debtor in possession? Yeah,
so that's going to be the United States trustee. And they do have some certain requirements. The debtor, when the Chapter 11 debtor is in bankruptcy court, they are required to file what's called monthly operating reports. They also have to pay trustee fees. So the watchdog is in effect the United States trustee. They kind of push the case to go forward. The bankruptcy judge will set some status conferences to hear from the debtor as to the status of the case, but they also lean a lot on the United States trustee as to what's going on and whether all the necessary filings are being made.
And for those of you who may be located in the South, what you will see if you ever look at a docket or you get a case in Alabama or North Carolina, you'll see this U.S. trustee referred to as a bankruptcy administrator. It's the same thing, basically. Mm-hmm. Call it something different, same role, same exact role in the case. Anything else I want to touch on? And debtor possession. No, I think we're good. All right, let's move on to, question number 6 now. So this is a big one. How are leases dealt with in bankruptcy cases? And I guess let's focus on Chapter 11 and 12 initially.
Okay. Yeah, so leases are, yeah, that's under section 365 of the Bankruptcy Code. And basically, a debtor has to determine whether they want the lease or not. They cannot modify it. They either have to assume it or reject it. Do you want it or not? There are some certain time frames on payments. So typically, a debtor will need to pay the lease payment each month in the Chapter 11 during the both prior to confirmation and post confirmation once it's assumed. The only exception is for the personal property, so your cars or other non-real estate items. The Bankruptcy Code gives a 60-day respite period basically to decide whether the creditor wants to make payments or not. But after that 60-day period on the personal property, the leases should be paid going forward. There is some, I mentioned the debtor has to either approve or reject those leases in their entirety. The deadline typically is plan confirmation. So the debtor needs to either to put in their plan whether they're going to assume or reject the lease. And they can do it earlier through a motion, but typically it's done through a plan provision. In the past, prior to 2005, I believe, as creditors, we used to file a motion to provide a time period for which the debtor has to assume or reject the lease prior to confirmation. But the case law out there since then, it really gives the debtor the right to wait until confirmation in order to make that decision. And the reason for that is if the debtor assumes a lease pre-confirmation and the debtor ultimately is not successful and they convert to a Chapter 7, that approval is binding on the Chapter 7 estate. So the reason the court allows until plan confirmation is they don't want to put the debtor in that situation should things go south and the case is converted to a Chapter 7.
So I'm going to sort of pose this question as a hypothetical. You're a creditor. You've got a lease of some equipment out there with a debtor who's in Chapter 11, and several months have passed, and you're not seeing any payments, and there's been no movement. What would you counsel that client to do?
Yeah, so the first thing I look at is, so if I'm taking the call, I'll say, well, when was the bankruptcy filed? Because I want to make sure that 60-day period is passed. Two, yeah, it's not real estate, so it's personal property. Under the Bankruptcy Code, after that 60 days, payments should be made, and if they're not, we need to file a relief from stay to either get relief from stay so that we can get you can get your leased equipment back, or the debtor is going to make payment arrangements to get that lease current.
And then there's another aspect of leases, especially in Chapter 11. Can you discuss just a little bit the concept of the cure amounts? You know, kind of keeping an eye out for that. It's usually happening in conjunction with plan confirmation. It's right there at the end, and it's something people can easily miss, and it can cost you.
Sure. So there's two situations with that. First is if the debtor wants to assume the lease, and they put in their plan, yeah, I want to assume lease A with Bank ABC. The debtor should have been making all of their post-petition payments, but there should be a plan provision as to the pre-petition arrears. because technically the debtor should not be making payments on their pre-petition arrears post-petition. So that should really be dealt with in the plan. So what we're looking for when we see a Chapter 11 plan filed is if they're current on the post-petition payments, and two, are they addressing your arrears? And in order to address them, the code says they must be promptly cured. And different jurisdictions have different definitions of prompt, but generally I would say within 6 months of the plan being approved, that those leases must be cured. The other situation is where in these Chapter 11s, a lot of times these businesses are sold. So when the assets are sold, generally you'll see a motion to sell assets free and clear, and these will be in an asset purchase agreement or in the motion that says, yeah, we want to sell these to the highest bidder. And once we have a bidder or a purchaser, a successful bidder, I should say, they make a decision on what leases they want to assume and what they don't want, what they want to reject. So the debtor wants to give the new buyer the option of whether to assume or reject your lease. So in making that determination, the debtor will file a motion to cure that says, here's your cure amount, and we're going to be waiting on the decision of whether the purchaser wants to assume or reject your lease. But if you don't agree with this cure amount within this motion, you need to object and tell us. You really need to look out for that motion to cure notice that's going out, and object to it if necessary, because if you don't object in time, it's going to be, those arrears are going to be wiped out, or they'll be paid according to that motion.
Right. If they undershoot your arrears, if you think they're a year behind in payments and they claim they're only 2 months behind and you don't object, to get locked in accepting 2 months where they, no, now we're current. Now we're current. So gotta keep an eye out for those cure notices. Anything else on leases? Got it. All right, move on to question number 7. Okay, so we kind of touched on this before, but if there's any more detail you want to give as to, when a plan gets filed in a Chapter 11 and the process, and maybe talk a little bit about the disclosure statement.
Yeah, so in the Chapter 11, again, it's 120 days for both the corporate and the individual Chapter 11. In the small business case, it's due within 90 days of the bankruptcy filing.
Can I stop you there for a minute, Jeff?
Sure.
Can anyone else file a plan? Can any other competing creditor or interested party file a plan in that first 120 days?
Yeah, you read my mind. I was just about going there. Yeah, so these 120 days, that's sometimes referred to as the exclusivity period. And what that means is only the debtor can file a plan within those first 120 days. After the 120 days, a creditor can propose its plan. A lot of times after that or before that 120 days passes, the debtor may file a motion to extend the time for the exclusivity period so that they maintain that right to file their plan. One thing I will note too is in the new small business statute, there is no exclusivity period because only the debtor can file a plan under that section, under the small business section. along with the plan in the corporate Chapter 11 filing, they typically file what's called or it's mandatory to file what's called a disclosure statement along with the plan. And the disclosure statement is all the financial information related to the case. It gives the background of the case. It gives what happened, why they're in Chapter 11. It lists the assets. It lists the projections going forward. And it's there so that a creditor can look to see what's going on and whether they want to vote to accept the plan as filed. And they use a standard called the reasonable investor standard to determine whether a disclosure statement is appropriate or not. If there's enough information there for a reasonable investor to make a decision on whether the plan is going to be successful, then that will suffice. And again, with the small business reorganization that was just passed this past year, there is no disclosure statement that's necessary. So again, you'll see with that new Small Business Act, Congress was really trying to streamline the Chapter 11 process so that these Chapter 11 debtors can get in and out of bankruptcy pretty quickly.
Thank you, Jeff. I'm going to plug in a couple of questions here that I'm getting from the attendees, the audience. One question I'm seeing here is, someone asked, I anticipated seeing a rise in bankruptcy filings due to debtors being affected by COVID. I've not yet seen a significant uptick, seeing an increase in filings. So I can take a shot at it, and Jeff can certainly as well. We are seeing a slight uptick in filings in terms of the referrals coming in our various clients. I can tell you that there was a slight increase of about 1% in bankruptcy filings from September to October in the numbers. But I will tell you overall, obviously, as everybody knows, the picture is, depends on how you look at it, bleak or not bleak in terms of the economy, but there are far fewer bankruptcy filings in 2020 than there were in 2019, to the tune of about probably a 40% drop at any given time, right now as compared to that same time period last year. But we did see a slight increase from September to October, and we'll see what October to November does. So we're seeing a slight one, and the anticipation would be as we get to the end of this year, but depending on what additional stimulus packages are proposed and or passed by Congress, that may affect what I'm about to say. But we do anticipate as we move into the new year, bankruptcies will start to step up. I don't think it's going to go like this, but we will start to see bankruptcies filed. And part of that's going to have to do with a lot of these assistance programs running out. Businesses and individuals will not have the lifeline anymore. The moratorium on foreclosures and evictions that has either been in place or that certain creditors have been voluntarily adhering to is going to fall off here soon by the end of the year. And if it does not get extended, you're going to see more foreclosures filed, more evictions filed, and those tend to be triggers for individuals and businesses to end up filing bankruptcy. And the same goes for a lot of creditors out there who have voluntarily or through state orders or guidance or advisement have not been filing lawsuits or have been holding off on certain types of collection, whether it's garnishments, bank attachments, whatever it may be. Those are also triggers for bankruptcy filing, and those are starting to come back. But for several months here, we saw very little of that across the industry, and that also kind of had a chilling effect on bankruptcy filing. So we're going to start to see them increase as the calendar turns. It's just a question of whether there's another round of stimulus that sort of slows that, what everyone wants to call it a tsunami. I don't think it's going to be a tsunami, but how steep the mountain is for bankruptcies to increase.
Yeah, I'll just add that Chapter 11s are up year over year. So the Chapter 11s have increased, and we all believe that bankruptcies are going to increase. I've been speaking with I'm a member of the American Bankruptcy Institute, and they anticipate a flood. I was on some conference calls with our judges, bankruptcy judges yesterday. There actually there's some bankruptcy vacancies in the Southern District of Ohio, and the reason they're not being filled is the cases are so low. They designate a bankruptcy judge based on how many filings are in the district, but they actually are filling some now because they anticipate a flood of bankruptcies that are being filed. So most people believe that it's coming, just don't know when.
All right. So let's move on to question number 8. So when will a creditor typically begin to receive payments in a Chapter 11 or a Chapter 12? I know it depends. It's a loaded question. Depends on the type of debt.
Yeah, so with the leases, you should be receiving them post-petition. And again, if it's personal property, it's typically after those 60 days, 60-day period. But with your other secured debt, you may not receive any payments until confirmation. In a Chapter 11, cash is king, so the debtor will try to preserve their cash and not pay a creditor if they don't have to. However, a creditor does have some rights, and they can file what's called a motion for adequate protection. The goal around a bankruptcy filing is when a bankruptcy is filed, you want to allow the debtor time to reorganize, but you don't want to be prejudicial to a secured creditor either. So the motion for adequate protection can be filed to allow the creditor to receive payments to the extent their collateral is depreciating. So you can file a motion for adequate protection. You may not get your regular monthly payment, but you may get, you should get the amount of the depreciation of your collateral.
Okay. So question number 9. If an individual's Chapter 11 is closed, can a creditor proceed with collection efforts?
Yeah, that can be a tricky question. It will depend on where the Chapter 11 is at, and what I mean by that is a Chapter 11 individual Chapter 11 can close, but the plan may still be proceeding. So if you look at the docket, the first thing I would do if I was asked this question on an individual or a particular case, I would look on the docket and see why the case is closed. So if I looked on the docket and I saw that there's a dismissal entered, creditor is good to proceed. But if I looked on the docket and saw that a plan was confirmed and then the case was closed, that's where I tell the creditor to stop and you cannot proceed with the collection efforts. And the reason being is in a Chapter 11 case, we discussed the U.S. trustee. They look over the case. They require certain monthly filings. They're entitled to fees based on the amounts of distribution while that debtor is in bankruptcy, and those fees can be substantial. So most of the time, once a Chapter 11 plan is confirmed, the debtor's attorney will close the case just so they don't have to pay those Chapter 11 trustee fees anymore. And then once the plan is completed, they'll go in, reopen the case, and the discharge will be issued. So yeah, you got to be careful if you see that a Chapter 11 is closed on the docket, because it can still be pending. Now, if there's a situation where you're not getting paid and you see that the case is closed, you can contact us. We can reopen the case and file a motion for relief from stay so that you can proceed with your state court rights at that time, whether it be repossession,
Move on to question number 10. This is a popular one we get. We're required to file a proof of claim in a Chapter 11 case.
Well, I'll start that one off by saying we always recommend a client to file a proof of claim in a Chapter 11 case, but you're not always required to. And what the bankruptcy rules provide is that if the debtor lists a creditor's claim on the schedules, and on the schedules they will list the amount of the claim and the value of the claim. But if a creditor agrees with the amount that's listed on the bankruptcy schedules, you don't have to file a claim. And the rationale behind this is the bankruptcy code and rules presume that these Chapter 11 debtors are more sophisticated, they're better record keepers, so that when they list something on the schedules, it's probably going to be right. So that's the reason you don't have to file a claim in a Chapter 11 if you agree with the amount on the schedules.
The caveat also being, though, if they have the amount right, but they list it as disputed or contingent, then you need to take action. Even if the number looks right, if they're saying it's disputed or it's in dispute, make sure you get a claim filed. So that's
correct.
The answer is file a claim.
Yeah. And the other reason too is a lot of these Chapter 11s, they may convert to a Chapter 7. And in those situations, you have to file a claim, but your claim that you filed in the Chapter 11 case will automatically transfer to the Chapter 7, so you won't have to refile the claim. So it's always better to file a claim.
Totally agree. So then the flip side here, question number 11, same question, but for Chapter 12. Are you required to file one in Chapter 12?
Yes, there's not a similar provision like that in Chapter 11. So yeah, you will need to file a claim. But like I said, you should probably always file a claim in your Chapter 7, 11, and 13s.
Totally agree. All right, so just a couple. I know we're almost out of time, but I want to throw out a couple of questions that we got from the audience. First one, what kind of communications can the creditor make with the debtor to arrange for post-petition payments that do not violate the stay? Well, I'll take a stab at it first and say, if you're trying to communicate with a debtor post-petition during the act of bankruptcy, it does violate the stay. My advice is those communications need to go through the debtor's counsel. That's number one, if you're not getting payment. And as Jeff alluded to, if you cannot voluntarily get that to happen, a motion for relief from stay or a motion for adequate protection payments is going to be your communication that you're really having. I mean, but there's nothing that prevents you from reaching out to a debtor's counsel themselves and saying, hey, look, can we make arrangements to start getting paid here?
Yep, that's right. And the other thing I'll add is if it is post-petition, you may be entitled to what's called an administrative priority claim. And those have to be paid prior to a plan confirming. So if you're not getting paid post-petition, you will need, they typically file they have a deadline to file those motion for administrative claims. So keep that in mind.
Yep. The last question I had from the audience was, how do you handle when a debtor claims the debt was included in a business bankruptcy filing, however, debt's completely in an individual, primarily a person or a primary person in the business has a signature unsecured loan or a secured car loan, but the business wasn't involved in the contract with the creditor. So I think I'm interpreting that as the business is claiming that it's wiped out, it's somehow been dealt with in the bankruptcy, but in fact, if I look at the contract, the underlying loan documents, the individual owner of the company is liable for it. And the short answer is it's that individual is still liable for the debt. So you need to look to the terms of the contract that were signed, and even if the business and the individual were liable and only the business filed, the individual does not get the benefit of the business's bankruptcy filing. The individual is still on the hook for that debt, and vice versa. If an individual files bankruptcy and his or her business is also liable on the debt, but the business is still operating, you can go after the business for the, any remaining portion that's owed on the debt. They don't get to ride on each other's coattails and benefit from the other one's bankruptcy. And
yeah, we see that a lot.
Go ahead.
I'm sorry. Yeah, we see that a lot with, Joe Smith follows the Chapter 7, doing business as Joe Smith LLC. We see that a lot. You look at only the individual name, not the DBA, yep. Especially if it's an LLC. So.
Exactly. All right, so we have hit the 12 o'clock hour. That hour went fast. I want to thank you for attending today's session, and we hope you found this presentation helpful and informative. To see all upcoming Weltman webinars, please visit the event tab on our website, weltman.com. And again, thank you for attending, and we both wish you a great rest of your day and rest of your week and rest of your month.
Thank you, everybody.
Thank you.